Corporations, Part 1, just the rules. So, corporations have legal personhood, liable in contract and tort. They have constitutional rights. What constitutional rights do they have? First Amendment rights, religious rights. What constitutional rights do they not have? Fourth Amendment, search and seizure. Self-incrimination, they don't have a right against self-incrimination. Okay, so what constitutional rights does a corporation have? That's right, First Amendment rights and religious rights. And what constitutional rights do they not have? No Fourth Amendment right against unreasonable search and seizure, no Fifth Amendment right against self-incrimination. Okay, so what's our main purpose of a corporation? Obviously, to make money for the shareholders and limit liability. And this is our corporate veil. And we're going to talk about piercing the corporate veil. The corporate veil is our shield from liability. Our articles of incorporation, there's 4 things we need. The corporate name, that's right. The number of authorized shares, that's right, which may be more or less than the outstanding shares. The name of the registered, that's right, agent for service of process, usually that's the Secretary of State, and that's right, incorporators, the people who set up the corporation. You know, there can also be promoters of the corporation prior to its existence. Remember, those promoters are personally liable for anything that they do prior to the formation of the corporation. So let's get that one out in the open. So our articles of incorporation are filed with the state. And then we have our bylaws, which are for corporate governance. Okay, so who has access to the bylaws? The shareholders. That's right. The shareholders have access to the corporate bylaws. And they also have access to the financials. We're going to discuss that in part 2. Okay, so those are our very, very basics of a corporation. Okay, so business judgment rule. Here's the rule. The business judgment rule operates as a presumption that the corporation and its directors are acting in good faith and with the best interests of the corporation in mind. The courts will not disturb an exercise of sound business judgment. If a shareholder wants to bring an action against a corporate board of directors, the burden is on who? The plaintiff, to overcome that presumption through a showing of bad faith. So, business judgment rule, let's try to repeat that. Courts will generally defer to the business judgment decisions of a corporation. It presumes directors are acting in, that's right, good faith and with the best interests of, that's right, the corporation in mind. And what does this result in? A shield from liability. Who's got the burden to show that the directors are not exercising their sound business judgment? The challenger, the plaintiff. The burden's on the challenger to overcome the presumption through a showing of what? Bad faith. And then the burden shifts back to the board of directors to show entire fairness. Okay, so burden initially on the challenger to overcome the business judgment rule presumption, showing of bad faith, and then the burden shifts to, that's right, the directors to show what? That's right, entire fairness. Absent a showing of bad faith, you're probably not going to get into court. So what's bad faith? Well, it's not just a bad outcome, lowered stock price, failure to declare a dividend. It's usually fraud, illegality, conflict of interest. Fraud, illegality, conflict of interest. Okay, let's try to repeat that again. Court's not going to interfere with the decisions of the board under their business judgment unless there is a showing of bad faith, which equals fraud, illegality, or, that's right, conflict of interest. Okay, moving along. So the business judgment rule leads to our next two topics. Number one, piercing the corporate veil. Secondly, usurping a business opportunity. And finally, direct and derivative suits. Okay, piercing the corporate veil. What does that mean? It means that the directors are normally insulated from liability pursuant to the business judgment rule. But under extreme circumstances, the court will hold a corporation's directors personally liable for the corporation's actions or their debts. So it's never enough. Remember, a bad decision, unsatisfied judgment, failure to declare a dividend, unpaid obligations. That's never enough. There has to be some sort of conflict of interest, fraud, or illegality. One theory under which the corporate veil might be pierced is the theory of enterprise liability. This is where we have a series of corporate entities that might be treated as a single enterprise for the purpose of liability. So remember, this is our taxi case where our friend had multiple taxi companies, each of which was minimally insured, right? So unity of interest in ownership, no distinction between the owners and the entity, commingling personal and corporate assets, not following the formalities of the corporate structure, and sanction fraud or promote injustice. Okay, so our enterprise liability theory is generally we looked at this in terms of LLCs, but we're generally talking about for unity of interest in ownership, sanction fraud, or promote injustice. We're talking about when the corporation is just somebody's alter ego. So let's talk more about what might, in a larger corporation, lead to piercing the corporate veil. Okay, so let's talk about business opportunities. Okay, so remember the eBay case. Shareholders brought a derivative action alleging that Goldman Sachs bribed eBay insiders by giving them IPO shares that rightfully belonged to eBay. So the board got these shares, sanctioned fraud, promote injustice, secret profits, violation of duty of loyalty, and they just got to sell them on the open market. So clearly that was one reason why one could pierce the corporate veil. Remember, sanction fraud, promote injustice. All right, so the corporation, our test here is interest or expectancy. Did the directors engage in impermissible self-dealing, where the corporation had an interest or expectancy in the opportunity? Or whether there's a conflict of interest. In eBay, clearly there's a conflict of interest because the corporation could have used those IPO shares for its own purposes. Okay, so is every interested transaction automatically out? No. Okay, remember the corporation itself has to have a what? That's right, interest or expectancy. So when is it okay for a corporate officer director to take a business opportunity for his own, where their corporation has an interest or expectancy? 3 prongs. 1, if it's authorized by a majority of the disinterested directors. This comes into play with Facebook. Approved by a vote of the stockholders, and the transaction is entirely fair to the corporation. So we have that entire fairness thing again. Okay. Corporation has an interest or expectancy. A corporate officer or director may take a business opportunity as his own if approved by a majority of the disinterested directors, approved in good faith by the stockholders, and it's entirely fair to the corporation. Okay, so this assumes that we're not hiding things. So our fourth prong here is the material facts have to be disclosed or known. Disclosed or known, approved by a majority of the disinterested directors, approved in good faith by a vote of the stockholders, and it's entirely fair to the corporation. If not, then we have an eBay situation in which the corporation itself can be sued by its shareholders, piercing the corporate veil. How do we do that? By a direct or a derivative suit. So shareholders, a direct suit alleges that the shareholders themselves have been harmed. A derivative suit, the shareholders are suing to protect the interests of the corporation, and the recovery goes where? To the corporation, that's right. So remember, who's the burden on? The burden's on the shareholders to show what? That's right, bad faith. Bad faith. Okay, so how do we go about bringing a derivative suit? Well, first of all, the shareholders make demand on the board to enforce a right or seek a recovery. Enforce a right or seek a recovery that belongs to the corporation. Okay, so the demand is the corporation has been harmed and the shareholders are bringing an action to do what? Enforce a right, that's right, or seek a, that's right, recovery that belongs to the corporation. Okay, so we're going to make demand on the board, and then the board's going to refuse. Okay, so remember, the burden's on the shareholders to show what? Bad faith. So the director's refusal has to be wrongful. Okay, so what does wrongful mean? The directors are biased. The directors are acting improperly. The directors are not independent. Demand is futile based on director independence, bias, directors acting improperly. Otherwise, it's going to be protected under the business judgment rule. Okay, so when is demand futile? When there's reason to doubt that the board could exercise its impartial business judgment. Okay, so this is best illustrated by our Facebook test. So demand will be excused as futile if the directors received some sort of material and personal benefit or would suffer substantial likelihood of liability. But the main thing is lack of independence from another person. Okay, so what's lack of independence? When a corporation is entirely under the personal control of someone like Mark Zuckerberg. Okay, so let's go back. First of all, shareholders to make a derivative, to exercise a derivative action, they first make what? That's right, demand on the board to do what? Enforce a right or seek a recovery that belongs to the corporation. They have to show the director's refusal was, that's right, wrongful. What's wrongful? They're not disinterested and they're not independent. They're biased. They're acting improperly. Okay, demand is excused as futile when there's reason to doubt that the board is capable of exercising sound business judgment. Okay, so under Facebook, lack of independence, material personal benefit. Lack of independence, material personal benefit. Okay, so what if the board can prove that the directors did act independently? The company can take back control of the lawsuit if it can prove director independence. Now the burden's on the corporation, remember, to prove entire fairness, good faith, independence, right? So if you're going to sue the corporation, you have to have standing, right? So our standing requirement is, of course, our regular requirements for standing: injury in fact, causation fairly traceable to the defendant, and favorable judicial decision will redress the wrong. But additionally, under the MBCA, a shareholder has standing if they are a shareholder at the time of the allegedly wrongful act and fairly represent the interests of the corporation. This is kind of like a class action. Remember, our class action, the representative has to be typical and representative. They have to be they fairly represent the interest of the corporation. So they have to be a shareholder at the time of the allegedly wrongful act or omission and fairly represent the interest of the corporation. So what are we going to do? We're going to make a written demand on the board to take action. Board says we're not going to pursue it, don't respond. 90 days later, under the MBCA, then you can file the derivative suit alleging that the board lacks independence, that they face a substantial likelihood of liability, that they couldn't exercise their sound business judgment. Okay, so that is part one. We're going to come to part two next.